I mean, I'm also covering just Jefferson.
Okay. Got you double duty.
A week.
Morning.
Hey, good morning. What? Jim? What happened to you? Oh.
Don't start.
She called in today.
Huh?
She called in.
Oh, I hope she's okay.
Yeah.
But I'll take one here any day.
Morning.
Ain't nothing against you.
Good morning. Good morning.
Yeah.
No,
Let me go there.
you was going somewhere.
You know I love you. You know I
It's
love you,
okay.
girl.
It's okay.
Just always.
We're gonna talk about it later.
Okay. Ooh.
Right now, we can talk.
Not good. Yeah, John's ready for this day, sir? You gonna do it, right? You ready for the day? Yeah. You want Oh, this is just a single ticket. Take it off. I gave you. All right. Everything ready?
I'm just gonna laugh at you right now.
Because of the job, Jeff, I wanted to, would you just be ready for yourself?
Ready for what?
For court.
Sir, I'm checking people in if you don't mind. I was just
Because we do things right, we don't be playing around in here. Good job, yeah.
Judge, close your ears, please. Please close your ears.
I believe we got one team. It might be, Jordan.
We only have one ready. Oh. Start.
Are you ready?
You ready? You open the court.
36th District Court, City of Detroit, State of Michigan, excuse me. Now, and we started, so 36th District, City of Detroit, State of Michigan is now in session with the Honorable Judge Giles presiding.
Okay, we are ready on Harris. Let me let him begin.
Yes.
All right. You did that. Calling case number 230-58923, People versus Christopher Thomas Harris. Defendant is charged with count 1, possession with intent to deliver 50 grams of controlled substance of oxycodone. This matter is up for a probable cause hearing. Appearances, please.
Philip Henderson on behalf of the people, P86029.
Good morning, Your Honor. For the record, Sterling Coleman on behalf of Christopher Harris.
Mr. Harris on?
Good morning, Your
Yes,
Honor.
sir.
Sir.
Okay.
Good morning.
So, Judge, if I may,
Go ahead.
so we're gonna ask for another PCC. I was just retained yesterday. I have not received discovery. So I'm asking that the PCC, this matter be adjourned to another day so we can get a better hold on what the charge is and how to proceed.
All right, Mr. I will adjourn the PCCs. And it's gonna be set out at least a week, so you have more than enough time to get discovery
Yes, sir.
and make the decision.
Judge, could I ask for the first week of October, maybe that Monday or Thursday?
Why are we putting it out that far? I'm supposed to do it.
Because next week I'm in different courts. I'm in Oakland County. I'm in Macomb County. I'm in Macomb County twice, Oakland County, and I may be in federal court out in Bay County as well. So, and that gives us a better feel, opportunity, not only to get the discovery, but for me to sit down with the client and go over it. So if I could ask, I'm asking for the week of the 2nd, October the 2nd.
October 2nd at 9:45?
Yes, sir. And that will be on Zoom, Your Honor?
No, that's in person.
And that's a PCC.
No, that's an exam.
Judge, if I
That's
have.
an exam. That's not a reason to adjourn the PCC. That's more than enough time for you to get discovery, Mr. Coleman. All you gotta do is send in an order. I'll sign the order. If they don't give you discovery, I'm gonna dismiss the case.
Thank you, Judge.
I gotta move the docket.
I understand. We'll be there at 9:45 on Monday, October the 2nd.
Okay, thank you.
Thank you.
Bonita, do you have another copy of the doc? I don't think mine's updated.
I got the docket already. I got it. You're my people. You got it. Give the program, I see that now.
I think mine's old.
Usually Kitty gives it to
Yeah,
her.
but it's old.
Kim says she's not.
Half of them are not here.
Your shenanigans.
I see.
Yes, want to go now, or you want to wait till? Yeah. Let's see what- You ready?
Everybody see what's happening. Go out the
No,
back.
I want to be here.
I know I'm. I can't walk. Yes. I need to be embarrassed.
We have a Jerika Campbell is in the waiting room that is not scheduled for today or in this courtroom.
Don't.
Then personal, a chat happened while they're here.
Yeah, I did, and they did not respond. Because this,
That might be the
Judge
problem.
King said it been,
Yeah, that might be the problem.
yes, I'm gonna leave it. I sent him a message, so.
Man, can I ask you to give me Monday's time?
Do, I guess we need Brown, if you willing to wait for, waive his client's presence.
Oh. Attorney Robert.
Robert Jurasik?
Are you running on Brown?
Yes.
Very interesting. Calling case number 230-57370, People versus QWAYVEION Brown. And the defendant is charged with count 1, police officer fleeing 3rd degree, and this matter is up for a proper cause hearing. Appearances, please.
Good morning, Philip Henderson on behalf of the people, P86029.
And good morning, Your Honor, Robert Jersey, P33195 on behalf of Flavion Brown.
All right, waive his appearance for the purpose of this hearing.
Yes.
All right, thank you. Can we do this September 27th at 9:30?
For an exam,
Yes.
let me just check. No, Your Honor, I'm in about 3 different courts that morning.
You can do later in the morning?
No, it's that morning is jammed.
September 28th at 9:15?
Could it be later? I gotta be in Warren for an exam that morning, and I know they never start on time, so that morning's not good either. Pardon?
10:45?
That would be tight. How about 11:30?
Don't have 11:30 available right now. I do 11.
We'll try at 11. That'll be fine.
September 28th at 11 o'clock. All right, anything else?
No, Your Honor. Thank you very much.
Thank you.
Mr. Kuja, are you ready on McClinton?
I am ready, but if I could just have a breakout room with him because he never answered the phone number that was provided to me. So I've had no conversation with him yet.
Okay, he's not present.
Oh. Okay then. I guess we're ready.
Calling case number 230-57950 versus Javon McClendon. Defendant is charged with count 1, felonious assault. This matter is up for a public cause hearing. Appearances, please.
Philip Henderson on behalf of the people, P86029.
And good morning, Your Honor. Jamil Kuja appearing on behalf of Javon McClendon.
Can you turn on your video, please?
Oh, I'm sorry, Judge.
Thank you. All right, waive his appearance for the purpose of this hearing.
Yes, Your Honor.
All right, send
Judge,
this
I'd
back
ask-
for-
Okay, go ahead.
Go ahead.
I was going to ask if we could just adjourn the PCC because I'd want to waive the exam, but I need to talk to him about that first.
No, I don't adjourn the PCCs. He knows what time this PCC was set for. He could have been here if he wanted to. So, he's either gonna show up or he's not.
Okay.
So,
What day are you looking at for exam?
you available September 27th at 10 o'clock.
Could I do a little later, like 11?
Yeah, I can do 11 o'clock.
Okay, so September 27th at 11 o'clock. Thank you, Judge.
Okay.
All right, have a good day, everybody.
You too.
He has 2 cases.
It's a nine for that. Oh.
Ross. See who's here?
I'm back. Thank you.
He's back with business. What do you think about it? Sure. Yeah. So it must be really bad. Yeah.
Anything else, Greg? Can you call upstairs for me? To Jefferson Court, see if there's anything.
You're still doing it.
That's the last thing.
Nick Mack, forget it. He told me he's coming in and called him. His brother answered his phone. I said, tell him to call. Here he comes. I don't know what's out there. Here you go.
Yeah, Nick Mack.
Yeah, that's true. That's so true.
Judge Johnson. Okay. Oh, too good. Okay. Okay, they said so far the only.
So number one.
Yes.
We're gonna do that one. Go back.
Okay.
Hopefully we have to, you know.
We're ready to start the exam then.
Chris, when I called up, Mr. Jordan, what to talk to him.
Yeah.
I talked to many.
All right. Yeah, Mr. Jordan. Yeah,
haven't called me.
This is my seventh case, so I don't know. How he doesn't know how I think by now we're in trouble.
That's true, I hear you. Whoa.
Gary Anderson. Oh, we didn't have one right now. Always. Your case could be, oh, for you. Right. Attorney Forrest.
Hi, good morning. I just making sure that Sterling Coleman came for Christopher Harris.
He did.
Okay, thank you.
You're welcome. Have a good day.
You too.
Yeah. I need to.
The person.
Oh. Me and that's on. All laid out. No, I wouldn't have bet me.
You hit TCU?
I took no, I took Colorado. Because it was like, I don't believe.
Yeah.
What? And I looked up, and it was like, I had 2 games, it was, Texas, the week before, over Alabama, and then the following week. Like 10 to 4. I'm sitting at 3 in the morning, I'm like, come on. And I'm like, oh, you gotta be kidding me. Colorado, but it was a game of Colorado State.
Yeah, they were, yeah. They was hit, they were trying, but did you have a spread?
No, I was just straight up.
Oh.
What site did you use to do that? What had to happen for instead of
I think it's 20 games.
Oh, 20 games.
Yeah,
I got you. Was it just like picking it straight or did you have to pick the spread?
No, I think it's true.
Yeah.
So. I mean, it's like, but yeah.
And then Saturday, college or
College,
Yeah.
anyone can win, like, for example, say you have like a 2 inches of single. Like, it's, you know, you never can tell.
On any given Saturday, picking any 20 games
Yeah.
is just, that's tough.
It is, South Carolina, they always beat you. Hey, it's hard to three-peat, you have to be able to further that. It's like, I think it's wide open. This is the first year I'm watching college football, it's wide open. Like, that Georgia's good, but they're not dominant with this year.
The thing that helped us really going back to back
Yeah.
was our quarterback had he was because of that COVID year,
Yeah.
he redshirted and the
Yeah.
COVID year didn't count. So he basically his last year he was older than everybody on the field. So and he had a year before we went back to back. He had a year where he kind of got to iron out all the kinks.
Yeah.
This guy, it's his first year actually
I know.
as a starter. It's gonna be really hard.
Yeah, because he just looks similar to like, well, Ohio State I feel last week, but it's like, doesn't, it's working through, you know, like with the other guys.
For us.
Yeah, Georgia.
Stetson Bennett.
Yeah, he was good. I mean, he knew, did he all through the ball, like right where he needed to be.
Yeah, he knew the offense and he had game experience. He had the moxie. Like this guy, he's just getting acclimated.
Yeah.
It's hard, even though I think he's a redshirt junior, but still, it's like if you don't know how to play in the SEC, who you play. Like you gotta have the guys running at you.
I don't know which game they may lose to, but the teams that they get will be tough this, Tennessee still could pull one out. I mean, they lost to Florida. Florida's decent, Kentucky, like, it's just gonna be a tough one. The SEC's gone, you know.
I'm very surprised.
They almost lost this, South Florida.
Yeah, that was shocking.
They better get together, because I'd see them 3 or 4 games with.
Just gonna be out the door, man, he might do that.
I know.
Yeah, cause you know, you don't wanna stay there if you're not getting crucial.
Yeah.
Crucible. Now they're going, we have to worry about Colorado getting recruits where he was.
I know.
Getting Georgia.
Yeah, what Dion is doing is exactly, he's making an event. He had Little Wayne come out played a song when they ran out the tunnel.
Yeah, so all the young kids who
Yeah,
enact with those people, which
yeah.
they weren't, they do weed and all, yeah, rock.
Yeah.
Here, man, so that's who,
Yeah, Dion knows what he's doing, and he can coach good. I mean, got good recipe.
but that's gonna get them some real good recruits.
Oh, yeah.
I already got, one of the top was already coming.
And the key to Sanders, his son, nobody thought like, he's legitimately a top prospect, Sanders, his son.
Yes, he is.
He was at, during the halftime.
We'll see after tomorrow's.
That's right.
It's good.
Oregon.
Oh, yeah.
We'll see if they're legit
City of
tomorrow.
USC
Who you?
coming up.
See, that's what I've been saying.
You were dating?
TCU's overrated because, you know, they lost everybody. And then Nebraska's the next. Well, they beat Oregon, then we got something. No, Oregon, Golden Age is good.
Yeah.
Judge Giles, courtroom 182.
Hey, this is Anita. We have a case.
Yeah, they are ending the case, and it's not gonna be domestic violence anymore, so we give it to you with Adjournment. This is from Judge Hughes. We are amending the case.
Oh,
No longer-
taking off the commission.
For consideration.
They fly drawn aside.
It is-
They just wanna give it to you, Now they there.
Is it for today? Yeah, because she said it's having to be. Yeah, just go ahead and fight as you're doing it. Are ready. Attorney Whitty,
Good morning.
good morning. You're ready on. Silly.
I think it's Silky, yeah. He should be coming in from the jail if he's online.
Okay, Joe hasn't zoomed in yet. Do you want to waive his appearance or no?
Well, we're gonna waive today, actually, so I can't.
Okay. I'm gonna wait until the Joe zooms in.
Okay, thank you.
Mr. Chris. Is that Mr. Davis, Mr. Cripps?
Yes, it is, Mr. Davis.
Just making sure. And then you have two cases. Calling case number 230-57626, People versus Devontae Davis. Defendant is charged with count 1, operating a chop shop, count 2, receiving and concealing stolen property motor vehicle, second offense that has a second or subsequent offense notice, counts 3, 4, 5. It's the same offense, and then count 6 is receiving and concealing stolen property, 20,000 or more. And the defendant is a habitual offender, has a 4th offense notice. This matter is up for an exam. Appearances, please.
Good morning, Your Honor. Ralph Alzano, P 4146 on behalf of people.
Good morning, Alexander.
Hey, good morning, Your Honor. David Cripps, P 34972, appearing on behalf of my client, Devonta Demario Lorenzo Davis, who's standing to my right. Tell the judge your name, please.
My name is Devonta Demario Lorenzo Davis.
Good morning.
Good morning, Judge.
Ready to proceed?
I believe so. I just need to check. We had subpoenaed approximately 4 or 5 people. I was on the phone with the officer in charge yesterday. They're all going to be here. I was just checking to see whether the subpoena time said 9 or 9:30, because I think originally 9:30 was the time on there. and then it was changed to 9 o'clock, so I just need to check, but I've got one of my officers here, if you can give me just a couple seconds.
Okay.
Do we have an amended order?
I can ask Anita to send over what she has. Sorry, Madam Clerk.
Good morning, Mr. Kaneki. Are you here for Mendenhall?
Yes, Madam Clerk, I am. I think he just joined us.
Yes.
That's how you know.
I need to know what the amended charges are.
Madam Clerk, could I get a breakout room briefly with Mr.
Madam
Mendenhall
Prosecutor.
before we go on the record?
Sure.
Madam Prosecutor.
Are you from King?
Yes, Your Honor.
What are the charges?
I think it was amended to felony firearm and felon in possession. I'm standing in for the AP record there, but I think Madam Clerk might have a copy. I'll ask her to email it over.
I don't know what you expect me to do if you can't tell me what charge it's supposed to be.
I think it's felony firearm and a felony. I'll double check. Give me one moment. I'll run over it. Or I can open it right here, actually.
Is there an order in there dismissing the other charges?
Nothing.
Okay. Well, I'll tell you what. Take it back.
Okay.
You bring me back an order that says what charges are dismissed. But right now, I have he's been arraigned on certain charges, correct?
Yes.
And certain, those charges are being dismissed.
Yes.
And that's why it's being transferred to me.
Yes.
Okay, not until I get an order. I need an order saying those charges are dismissed, and then I'll know what he's being, what we're gonna do.
Okay. Thank you, Your Honor.
We're ready. And thank you for the,
You swear or affirm to tell the whole truth and nothing but the truth, so help you God.
Yes, Your Honor.
You come on up. So I'm gonna, give me 1 second, I'm gonna do a couple PCCs.
No problem.
Just give them them dates. You come up here and see. All right, you call one of those.
This is party on Gray. Calling case number 230-58904, People versus Corey Gray. Defendant is charged with 1 second-degree arson. Defendant is a habitual offender, has a second offense notice. This matter is up for a proper cause hearing. Appearances, please.
Good morning, Judge. Adjournment on behalf of the people, P number P86590.
Gary Anderson on behalf of Mr. Gray, P27210.
Mr. Anderson, you willing to waive Mr. Gray's appearance for the purpose of this hearing?
Yes, Your Honor, I do believe that he is incarcerated based on the bond amount.
Okay, thank you. All right, we'll set this matter for example, right?
That's correct, Your Honor.
Are you available? Let's try it. September 29th at 9:30?
You know, I'm not, Your Honor. Can we do it the very next available date?
Well,
Or
how
even
about,
before?
how about September 28th at 11:15?
That works, Your Honor. Thank you.
Okay.
Thank you very much.
Great, thank you. I understand.
Well, could I ask the prosecutor to forward discovery? I do not know receipt.
Digital was sent, and discovery was sent on 9/21. I will resend that.
Please, thank you so much.
Yep.
Everyone have a good day.
You too now, take care.
Did he
Thank
waive his
you.
presence? Did he waive his presence?
Yes.
Attorney Choate, are you on Brock?
Yes, Your Honor, I am on Brock.
Calling case number 230-589-1601, People versus Sable Brock. Defendant is charged with count 7, 8, and 9. In this case, accessory after the fact to a felony. This matter is up for a probable cause hearing. Appearances, please.
Good morning, Judge. Alex Spring on behalf of the people, being number P86590.
And good morning, Your Honor, Alexandra Cho with the Neighborhood Defender Service P85948, appearing on behalf of Ms. Brock. Ms. Brock is not currently present in Zoom, Your Honor. I have spoken with Ms. Brock's mother. However, she does not have contact information that she can provide to me for Ms. Brock. I would request a brief adjournment just to get in contact with Ms. Brock.
It's denied. Ms. Brock knows she's had this case here today. She doesn't want to show up, that's fine. I'll waive her appearance for the day's purposes, but I'm gonna set an exam date.
Understood, Your Honor.
Are you available September 27th, 10 o'clock?
That is the only day I'm available next week, Your Honor. That is perfect. Or excuse me, could you say the date one more time, Your Honor?
September 27th at 10 o'clock.
Yes, okay. I just want to double check.
Okay. All right, anything else?
Your Honor, I do have a case that was set in front of Judge Jefferson. Her court had called and said that you were covering her docket this morning.
Yeah, I'll be back up there shortly.
Okay, I will zoom into hers then. Thank you.
Okay, thank you. All right, back on the record, 2357626. People State of Michigan versus Devontae Davis.
Good morning, sir.
Good morning.
Were you sworn in?
Yes.
Okay. Can you state your name, please?
John Matiba,
And how are you employed, sir?
City of Detroit, Detroit Police.
Okay. And you have a special assignment?
Commercial auto theft.
Now, I'm gonna ask you some questions, sir, concerning things that may or may not have happened on June 28th of 2023. Do you have some memory of some things that occurred on that date?
Yes.
Okay. And specifically, sir, at the location of 10701 Linden, City of Detroit, Wayne County, Michigan?
Yes.
Okay. Were you at that location sometime that day?
I was
Okay. Approximately what time would you have gotten there?
approximately 2 o'clock.
Okay. That's AM, PM?
8 p.m.
Okay. Now, why were you there?
Conducting a business inspection.
And what when you conduct these business inspections, what is it specifically that you're looking for when you go to these locations? Wait a minute, let me ask you this. Is there a specific type of business that you're doing the inspection for?
On this one, it would be a repair facility.
I'm sorry, what?
Repair facility.
Okay. And what gave you reason to believe that this was a repair facility?
It's large Midland Auto Parts on the front and numerous parts and activity outside. Not that day, but while we were watching it.
Okay. And we'll strike that. Well, let me ask you this: were you had you had contact with this particular facility prior to this date?
No.
Had prior to this date, had you made any observations of that facility?
Yes.
Okay. How and when was did that occur?
Approximately a week prior, observed bay doors open, subjects going in and out.
Now, when after these observations, there comes a point when, or based on these observations, what did you conclude at that point?
Went to the location to conduct a business.
Speculate.
You could indicate what, based on all of the factors you saw, what you concluded from that.
That's no speculation. All speculation. Tell me what he did. That's all I need to know.
Okay. That's it. All right. Now, after making these observations, you said that you came back a week later. Is that correct? Or sometime later?
Yes.
Okay. And at this point in time, was there a specific goal for you at that point that you wanted to do at that location?
Yes.
And that was to do what?
Conduct a business inspection.
And when you conduct a business inspection, what is it specifically that you're looking for when you do that?
I'm checking for a business license, a state license, major component part book, certified mechanic if any repairs are being done.
So those are the general goals when you go in for these examinations?
Yes.
Now, on the 28th, did you go to this Midland Auto Repair place?
Yes.
And were you by yourself when you went?
I was with my crew.
When you say your crew, who were you talking about?
I was with Officer Heather Thompson, Sergeant Lieutenant Dunning, Investigator Jake Way, Officer Hebner, and I believe a few other officers.
Okay. Now, when you get there, what's the first observations that you make when you approach this particular location?
I observed Mr. Davis sitting at council next to him wearing a black shirt. Drive up and start walking to the front door or the back door. He had a key in his hand.
Now, for the record, you've identified, the record reflects that he's identified the defendant, Mr. Davis. Thank you. All right. Now, you see him walking through, describe this facility. What are you looking at as far as the building or the buildings, whatever?
It is a large industrial building. It's on the front, has Midland Auto Parts on it. It's got two bay doors in the back with a one single door. The front has a bay door to it.
Were any of the doors open at the time that you approached?
They were not.
And now, you say that you saw Mr. Davis. When you first see him, what do you see him doing?
Walking towards the back door.
Okay. That's the back door of this facility?
Yes.
All right. And where are you when you make this observation?
I was pulling up.
Now, at that point, did you stop your car and get out?
Yes.
Okay. When you get out of your car, do you make any observations at that point?
At that point, I just went and talked to him.
Okay. Now, you said something about a key. When did you make an observation of a key?
Yes.
Okay, when's the first time you saw a key?
When I was walking up to him.
Okay. And where was this key?
In his hand.
All right. Now, when you walk up to him, Mr. Davis, where do you confront him, or where do you interact with him?
Near the side door, back door.
And when you first interact with Mr. Davis, what did you do?
I asked him what he was doing here.
Did he respond?
He stated he was here to see somebody.
Did you have any further conversation with him during this encounter about why he was there?
After he said that?
Yeah.
Yes.
Okay, and when did that occur?
After stolen parts were ID'd.
Now, and at that point, what, if any, conversation did you have with Mr. Davis?
He then stated that he did work there for over 2 years.
Now, this key, what happened with the key?
After the search warrant was signed, the key opened up the lock that let us inside.
No foundation, Your Honor.
Well, he can testify to what happened. I mean, it's-
Okay, hold on. I don't understand you said no foundation.
Yeah, there's no foundation that anybody used the key to open up any door. He said the key operated a door, but I didn't hear him testify that he went and did that himself to see if it opened the door, or whether somebody else did that and gave him that information. That's what I'm objecting to.
Okay.
You know what, Judge, I'm gonna build that anyway, so
Thank you.
let me beef it up. All right, now, you said that while you were speaking with Mr. Davis, there were other people from your crew on the lot?
Yes.
All right, and while you were speaking to the, Mr. Davis, is, Mr. Jakeway there?
Yes.
Jakeway. Okay, who is Mr. Jakeway?
Jakeway is our identification expert.
Okay. And while you were talking to Mr. Davis, could you tell what Mr. Jakeway was doing?
Yes, he went over to a pile of where there was an engine, transmission, doors, hoods, interior. It was a 2022 Dodge Durango.
Okay. And did, as far as you observed after he went there, did he do anything as far as concerning those parts?
Yes, he came back and notified us that it was stolen.
Can I speak with counsel one quick second?
Sure.
Okay, I got you.
All right, well,
Thank you, Judge. All right.
Objections sustained.
At that point, after speaking with Mr. Jakeway, what happened?
At that point, I locked up Mr. Davis and search warrant was typed.
Okay, so at that point, after talking with Mr. Jakeway, Mr. Davis was taken into custody at that point?
That is correct.
Okay. And were you the person who put him into custody?
Yes.
Okay, and what were the grounds for him being placed in custody at that point?
Receiving and concealing stolen property.
And was that based on information you received from Mr. Jakeway?
Yes.
Now, after Mr. Jakeway, or after Mr. Davis is placed into custody, you said that a search warrant was obtained?
That is correct.
Okay, and with the search warrant, did you have personal knowledge what the search warrant was authorizing?
Yes.
Okay, what was it authorizing?
Recovering stolen parts, vehicles.
Did it authorize entry into that building?
Yes.
Now, was entry made into the building based on the search warrant?
Yes.
Okay. What method was used for entry into the building?
The key Mr. Davis had.
And that key did what?
It opened up the padlock that was locking the door.
Now, you said that you went in for a business inspection, and part of it is to request books and other things, is that correct?
That is correct.
Was that request made of Mr. Davis prior to him being put in custody?
No,
Now, once the entry is made into the building itself, and you entered into the building?
yes.
Okay, what did you observe when you went in?
I observed approximately 5 vehicles inside. I observed numerous car parts throughout the building.
What was the condition of the vehicles you observed?
They looked like they were being worked on.
After the search warrant was conducted, was someone responsible for filling out the return, if you know?
Yes.
Okay, who was that of them?
Either Alexis Campbell or Heather Thomas. I'd have to take a look.
Do you have your file with you? Refresh your recollection.
And I'm not sure on that. She didn't sign it.
Okay, but a return was, as far as you know, it was a return made.
Yes.
All right. After, while the search is going on, where is Mr. Davis?
He was in custody.
Okay. Do you have him, was he in a vehicle? Was he outside? Do you know where he was?
I'm not sure at this. He was out. He was outside.
Okay. While you were there, or let me go back to, while you were there that day and when you drove up, did any other individuals approach the shop or approach that building?
Yes.
Okay. Did any, were they spoken to?
Yes.
Okay. Did any of the individuals who approached the building indicate anything about working there?
Working there? No.
Was there any documentation? Well, no, sir. Okay. So essentially, what you just testified to is the essence of what you did, saw, heard at that location on that day. Is that correct?
That is correct.
I have no further questions.
No questions, Your Honor.
I believe we have some stipulations that we're going to enter into. That would be that there were at least 3, if not, well, there were at least 3 parts found that were found to be stolen, located at that location. The parts being, I'll tell you here. Let's see here, a white 2014 Chevy with a VIN number ending in 7225. A burgundy 2011 Buick LaCrosse with a VIN number ending in 208. Let's see here, another 2017 Dodge Charger 300, VIN number ending in 5813. A black 2013 Dodge Journey, VIN number ending in 3640. 2014 Nissan Rogue, VIN number ending in 603. I think the stipulation would be that, first of all, that those vehicles were located at that location.
Correct.
So stipulated for exam purposes, Your Honor.
Right. Okay, accept that stipulation for exam purposes only.
All right, and then as to those vehicles that the officers.
Put your system on mute, please. Put
You
your
want to get me?
system
You
on.
telling me to get somebody else? He on.
Hold on 1 second.
That further with those vehicles, if the officers, an officer checked with the owner of those vehicles via telephone, found that those vehicles had been reported stolen, that they had not given permission to anyone to possess those vehicles. I think that would be the extent of that stipulation.
The second stipulation that there was a hearsay statement as to these vehicles, that they were reported stolen and given no one permission to take them or do anything with them. Is that correct?
Correct.
And we're prepared to enter into that stipulation for exam purposes.
Okay, court will accept that stipulation for exam purposes only.
Thank you, Your Honor.
1 second, let me catch up.
Now, I know it's a notice, that's the second thing I noticed, that's to counts 2, 3, 4, 5. Four and 5. I believe counsel is willing to stipulate that the defendant was in fact convicted of violating 750.535 on 11/12/2018 in the Third Circuit Court of Wayne County.
Convicted of receiving, concealing vehicle, eight vehicles. On 11/12/18, is that correct?
Correct.
Wayne County. Is that correct, Mr. Phelps?
Yes, Your Honor, it is. It is correct.
He's charged as a habitual offender for the information for the complaint lists 3 prior convictions, 1 on 11/12/18 for receiving, concealing stolen motor vehicle, 1 on 11/12/18 for
Habitual offender, that's province of across the street.
No problem. Okay. And I believe with that, Your Honor, we have no further evidence to present.
Does have any evidence?
No, Your Honor, we're not presenting any witnesses.
Argument.
Your Honor, I believe that the elements for all of these charges have been met. I think the specific one, I'm anticipating counsel's objection here, the specific one being that the defendant had knowledge of the fact that these vehicles were stolen. I think that probably would be the little kink in the case here for me, Judge. The evidence tells us that Mr. Davis was present at that location. Well, first of all, it tells us there were numerous stolen vehicles and parts at that location. It tells us that nobody else was at that time at that location involved with the building. The only person involved with the building was Mr. Davis. Now, Mr. Davis originally tells the police that he's there to visit a friend. That statement, in and of itself, if that's what he had said, I'd say, you know, we don't really have probable cause here at this point, because that could be true. But Mr. Davis does have the key to the premises. There is no one else working there. Mr. Davis is the only person at that location with control and dominion over that building, with that key, control and dominion over whatever's out in that line. The fact that there are no books that are required by statute for places having used vehicles or the repair facilities. The fact that they're not there, I think, is also indicative of the fact that the person in charge of that obviously is the person involved in that with that building is obviously taking parts. And because they're not recording it, and that I think that's really crucial, because those books that are supposed to be kept are there to really prevent stolen parts from being conveyed. There's supposed to be very specific information on who they bought it from. There's supposed to be very specific information on how it was paid, specific ways to make payment on these things, things that would indicate a fair and honest dealing going on at that location. The fact that the books are not there, I think, is also further indicia of a business that is being run for the purpose of receiving stolen motor vehicle parts. Now, Mr. Davis, again, is the only person on that day that has dominion and control over that building. There's nothing in the building that would lead us to believe that these parts were being received according to law. And while I guess it's a close call, but I think it's sufficient for probable cause purposes, Your Honor, to bind over, and that would be my argument, and that would be my request.
So the defense would object to a bind over here for insufficient evidence, Your Honor. This statute that my client is charged with, operating a chop shop, and the other charges for receiving and concealing stolen property, have to show that he had guilty knowledge and that he was in control of those items. It has to be showing that he knowingly owned, operated, or conducted a chop shop. All that we have in this case is my client walking towards that location with the key. He initially says he's here to see someone, not here to see a friend. I wrote down what the officer said, here to see someone. And then after they question him further, he says, I've worked here for 2 years. Now, those are all the real facts we have in this case in relation to my client. And we believe that fails to show the elements of either operating a chop shop or receiving, concealing stolen property, and ask you to dismiss the charges.
Very well. No. All right, court having heard the testimony, argument as follows. Detective Mativa, isn't it? Detective.
Mativa.
Yeah, I know Mativa, I couldn't remember the sergeant or detective. Okay, Detective Mativa from the Commercial Auto Theft Unit. That on June 28, 23, in the area of 1071 Linden, which is Midland Auto Parts. You arrived at the location approximately 2:00 p.m., conducting a business inspection. Described as some type of repair facility. He had been there 1 week prior, making observations. The bay doors were open. There were numerous people going in and out. Went there checking for license, certified mechanic, and parts book, which He was with his crew, which was with 5 to 7 officers. He observed the defendant. We described Mr. Davis drive up and then get out, start walking towards the back door. He then got out of his vehicle and approached him. Mr. Davis initially said he was there to see someone. And then afterwards, he then stated that he had been working there for 2 years. There were numerous vehicles, 2014 Chevy, a 2011 Buick, 2017 Charger, 2013 Journey, 2014 Rogue, which was stipulated to that these vehicles were stolen. And that the also as to the hearsay, so the stipulation as to the hearsay statement, wherein that the vehicles were stolen, no one was given permission to take them. And further that further stipulation that the defendant was convicted previously receiving concealed stolen property out of a vehicle and on 11/12/2018. The court is allowed, I mean, the case is circumstantial, let's put it that way, as it relates to certain aspects. And that would be primarily the knowledge aspect. The court is allowed to infer certain facts based upon the facts that are presented. And here we have the defendant who goes to this building. He has the key to the building. And states that he had been working there for 2 years. I would have to believe that and infer that if he had been working in this business for 2 years, he would know the requirements of working in that business, which in this case were not met. So at this point, it's the standard being probable cause. It's a reasonable jury could infer from these facts that he was involved in some type, form, or fashion with this business, and well, since he obviously was working there, and with operating the chop shop and receiving concealed and stolen property. The court finds that those felonies, in fact, are the felonies enumerated in the complaint warrant. Because of his history, that's at count 3, 4, 5. In fact, occur in the city of Detroit, probably causes this charge this defendant to be bound over to Wayne County Circuit Court Criminal Division for arraignment on the information, which will be October 6th at 9 o'clock.
Thank you, Joseph.
Thank you.
Thank you.
Thank you.
We ask that the bond be continued.
Bond is continued.
Your Honor, my client wishes to address the court about tether conditions. I believe he's on home arrest right now, is that correct, sir?
Correct.
And you would like some time out for employment?
Yes.
Can you tell the judge where you're employed?
I would normally reside in diesel truck work. Like I would do diesel work. That's what that yard was for. That's why I was at the yard.
Sir,
No,
I'm
I need
asking
to
where
hear
you
about
work,
it.
not to go into the facts of the case.
I'm sorry, I'm sorry, I'm sorry.
My client is,
I do diesel work.
Okay, hold on. We have a very good attorney sitting next to you.
I know.
You need to listen.
I know.
This is the only thing I can tell you.
Okay.
You need to listen to him. If he tells you to be quiet, you need to be quiet, because everything that's said in this courtroom goes on that record. Everything. All right. So you just made another admission about being there. on the record, which the prosecutor can use against you across the street. Now, this is a simple question. Well, let me clarify that question. Let me refine it. I guess is a better word. Are you working at someplace other than Midland Auto Parts?
Yeah,
Where?
it's a diesel company. It's called Freight Lines.
Where is that?
Greenfield, no, Plymouth and Evergreen area.
And is this a regular job? Is this under the table? Is this, what is this?
It's under the table diesel work.
Are you licensed?
Permit.
I don't know what a permit is. You know, mechanics get a license. I've never heard of a mechanic with a permit.
My pop was a diesel mechanic.
I beg your pardon?
My pop was a diesel mechanic, so I wanted to use his license.
So you're not licensed?
Just permit.
You're not permitted. There's no such thing as a permit for a mechanic.
That's what they gave me, it was a little permit slip, because I didn't make it to the test.
But you don't have a license. You need to stop talking, because you're not making any better.
My apologies.
That's the attorney, not me. I'm not, I make the decision, but you making his job harder. Let's put it that way. Prosecution wishes to address the issue of bond.
Yeah, it seems to me that that issue could be addressed when we go forward with the DSU referral. Maybe today, I would ask you probably to do that. There needs to be, in my opinion, some confirmation of where, when, this employment occurs. Otherwise, how do we know what hours? I mean, I'm amenable always if defendant is out, is working, to let them work. But we don't really have anything sufficient to really show where, when, and why this is needed. So I'd ask it be referred to DSU, and I'd ask that that information be given to them and let them decide.
Any last words? Any last words?
No, Judge, I'm just trying to allow him to work, that's all. And if you require a letter, we'll get it.
You know, of course, the issue of bond is just twofold. One is to ensure that he comes to court, which doesn't appear to be an issue that he's here. The other is to protect the community. You know, what he's charged with are what we consider non-violent offenses. You know, the harm against the community is building, of course, building in the stolen property, or these stolen vehicles. I will amend the, your tether to allow you out to work. You're gonna have to provide to the tether unit documentation from where you're working. You know, the hours, et cetera, that you're working. And who do you live with?
Myself. My girlfriend.
Then I'm gonna allow at least for one day, 8 hours. It's gonna take care of personal business, food, pay bills, whatever, that kind of thing.
That's
You
fine.
have to do that. All right, so you provide documentation to tether, you know, your hours from your employer. And, but I'll allow you to at least Fridays or Saturdays, whatever, for 8 hours so you can take care of business.
Thank you.
All right, Mr. Krebs, we can prepare order, please.
I will, Your Honor.
All right. Okay, thank you.
Thank you, Judge. Good seeing you.
Good seeing you.
We're not going for anything else, we're outside. This is bond reduction.
Yeah, the bond.
Your Honor, Lita called, she said, they had 5 ready, but I do also have.
All right, so let's go and I did work on 9 days here. So I can take this down. Let you know. See. Yeah, how you
APA, counsel, what is your P number? I'm sorry, I didn't catch. 414, I'm talking to
Mr.
you.
Alessandro?
414-463.
I'm sorry, I didn't hear.
414-463.
414.
Oh, she's getting.
Oh, that's too many
Repeat
numbers.
number.
Huh?
Take it.
414.
15.
414.
63.
Oh, 63.
I'll take the report.
Judge, may I approach?
Sure.
Dwayne, Jordan case, and his witness officer is testifying upstairs right now. On 10th Jordan at 9:30. Yeah, okay. Yep. Today's actually my birthday. I was like, wait a second, I'm not supposed to be working on my birthday. But Lauren said I can work from home after this, so that's good. Yeah. Thank you. 34, I'm old.
Oh.
Yeah.
Oh, great, get out of here.
Times that by 2 and you got Tyrone.
That's right. Well, he was so.
Okay, this is on Mendenhall. Calling case number 2305778, People versus Joseph Mendenhall. Defendant is charged with count 1, possession by felon, count 2, possession of felony firearms. Defendant is a habitual offender, has a second offense notice. This matter will for a probable cause hearing. Appearances, please.
Philip Henderson on behalf of the people, PA 6029.
May it please the court, Neighborhood Defender Service of Detroit by Jeffrey Konecki, P 64800 on behalf of Mr. Mendenhall. Mr. Mendenhall, please state your name for the record.
Joseph Mendenhall.
Mendenhall, so that you know in the future, I don't do t-shirts in my courtroom, t-shirts or sweats. So when you come back to court, please dress for court, okay?
Okay, I apologize. I was about to go to work. My bad. I apologize.
Right, just so you know when you come back to court. All right, thank you.
Okay, thank you.
All right. Counsel?
Your Honor, I'm sorry, before we get to like setting an exam, I did need to make a motion to the court. I need to make a motion to withdraw. I believe that the attorney-client relationship with Mr. Mendenhall has been degraded to the point where we no longer have productive conversations. I think Mr. Mendenhall needs new counsel that he can start fresh with, because at this point, the relationship is irreparable.
Why?
He doesn't seem to think so, counsel.
I understand we've had a number of discussions about it. I really can't go into too much without violating attorney-client privilege, Your Honor. But in Mr. Mendenhall's best interest would be for him to have new representation so he can fully explore his options on the case.
Mr. Mendenhall, you got anything you want to say?
All I did was ask questions, but if he don't want me, what can I do? But all I asked them is they closed the case, and I was just trying to, they closed one case and changed me to another case.
I would advise you not to discuss the case, Mr. Mendenhall.
Okay.
See, I'm not saying where there's I understand what you said. You said the words, but you haven't said anything that said that. And he's not agreeing with it. You know, he's not seeing as a problem with you that there's a breakdown. You know, he's asked questions, obviously you answer them. You know, you may not have liked the answers, but you know, they are what they are.
Your Honor, I guess maybe I should voice it another way. I think that based on my conversations with Mr. Mendenhall, I have to ethically ask to withdraw. I should have phrased that better when I first approached the court.
All I asked you, sir, was.
Mr. Mendenhall.
Mendenhall, stop, please. At this point, I'm gonna allow him withdraw. I'm gonna get you a new attorney. So, you're gonna have to hold on while we call and get you a new attorney.
Is they gonna get all my information, please?
Are they gonna what?
Is they gonna get all the information that he got? I want the body cam too.
Yes, he'll provide all the information.
Okay.
All right, and then the attorney can go over all that stuff with you.
Yes,
Your Honor, if once the new attorney is determined, the court is still free to give them my contact information. I can send them what I have, try to expedite the process.
He mad at me.
No, don't say anything, Mr. Mendenhall, please. We're gonna have to get you a new attorney. Put your system on mute, we'll recall your case shortly.
All right, but can I ask you one question? One question, please.
You're gonna ask. I don't know about
Yes.
my answer.
So it was two cases. That's the only way. They had dropped the domestic.
They dropped the domestic violence. Right now, you're looking at, let me see.
Mr. Mendenhall is muted. It appears he's still talking,
Okay.
but doesn't realize
What
he's
we're
muted.
gonna do is, okay, I'm gonna change this. You're gonna come back Monday morning, Mr. Mendenhall, because I gotta send this back. There's no order in here. I'm not taking this case. There's no order in here. Hold on. I'm talking. Hold on, please.
Okay.
I said I wouldn't take it if there was an order specifically saying what the charges are. There is none. I'm not taking the case, take it back wherever it came from, whatever. Until I get an order, I'm not taking it. So right now,
It's an amended order.
where?
These are the new charges.
What amended order?
It's right in time. It says amended.
Yeah, because they supposed to cancel everything.
But where's the order dismissing the, Mr. Mendenhall, would you please stop talking? You know, you're gonna say something and it's not gonna do you any good. So please, just stop talking. Okay, I still need an order. I need an order dismissing these other, I got two complaints in here. I got an amended complaint, and I got a complaint. What am I supposed to do with it?
Your Honor, this is coming from another prosecutor. Our office, so we'll have to check with them. I guess it wasn't done right, so.
Okay, Mr. Mendenhall, come back Monday morning. We'll have you a new attorney. We'll have all this worked out by then, 8:30. All right?
Okay, but he ain't finished actually. I'm still on the tether, and I can't go home. And that's the only way I was looking.
You're gonna be on the tether until Monday morning. I'm not doing anything on this case until I know that it's mine and I got it and it's right.
Okay, because my girl, yes, it's her gun license. She wrote the paper and everything. I ain't have no.
Mr. Mendenhall, don't talk about the case.
Listen to what I'm saying. Monday morning, 8:30, you come back on Zoom, wear a shirt with a collar. Do you understand? I will deal with everything then. Until this case is transferred to me correctly, I'm not dealing with anything. All right? Do you understand? I hear you on mute. Okay. Monday morning, 8:30.
Thank you, Judge.
I understand.
All right.
Could you repeat the case for me, Juanita?
Sorry, say that again.
Can you repeat the case number for me?
It's 2305777.
78.
All right. Mr. Whitty, still here?
Yes, I'm here.
All right, your client is here.
Perfect. And this is going to be a waiver.
All right. Calling case number 230-55586, People versus Gregory Silky. Defendant is charged with count 1, possession of methamphetamine, ecstasy. Defendant is a habitual offender, has a third offense notice. This matter is up for proper prosecution.
Philip Henderson on behalf of the people, P86129.
And good morning, Your Honor. Dennis Whitey, P79560 on behalf of Mr. Silky, who appears by Zoom from the Wayne County Jail.
Oh, okay. Mr. Silky, state your name for the record, please.
You have to unmute.
You have to unmute yourself.
Can you hear me now?
Yes.
All right, Gregory Michael Selke Jr.
Thank you. Counsel?
Your Honor, today's a day and time set for a probable cause conference. I have met with my client a few days ago to discuss his rights to a preliminary examination along with all time frames. My client wishes to waive his right to a preliminary exam today and have this matter bound over to the Wayne County Circuit Court for further proceedings.
No objection, Your Honor.
Thank you. All right, Mr. Silky, you understand that you have a statutory right to a preliminary exam where the state must show by probable cause a crime was committed and probable cause you had something to do with committing it. You understand that?
Yes, sir.
Anybody promise you anything or threaten you in any way to get you to waive your right to preliminary exam?
No, sir.
You waive your right freely and voluntarily after having opportunity to talk to your attorney about it.
Yes.
Say yes?
Yes, sir.
All right. And do you have any objection to the court signing your name to the waiver form and initialing off?
Excuse me, you broke up.
Do you have any objection to the court signing your name to the waiver form and initialing off on it?
No.
And Mr. Whitty, do you have any objection to the court signing your name to the waiver form and initialing off?
No, Your Honor. Thanks for doing so.
All right, then the court will find you freely and voluntarily waive your right to preliminary exam as bound over the Wayne County Circuit Court Criminal Division for arraignment on the information, which will be 9/29 at 9 o'clock.
9/29 at 9 o'clock. Thank you, Your Honor.
Thank you.
Take care, everyone.
All right, take care. Good weekend. What is this one? What's this one?
This right here is a real waiver.
Yeah, it's a canon.
I'm just letting you know.
Oh, thank you. Calling case number 230-58799, People versus Randall Cannon. Defendant is charged with count 1, carrying a concealed weapon. Count 2, possession of a felony firearm. Count 3, possession of ammunition. Count 4, possession of a firearm, as well as count 5. Defendant is a habitual offender, has a second offense notice. This matter is up for an exam.
Good morning, Judge Alex Waring on behalf of the people, P number P86590.
Good morning, Your Honor. May it please this honorable court, Attorney Phyllis Gayton Robinson, P71733 on behalf of Mr. Cannon. Mr. Cannon, can you please state your name for the record?
Michael Cannon, Jr.
Thank you, sir.
Your Honor, today is the date and time set for a preliminary exam in this matter. I have spoken to Mr. Cannon about his right to a preliminary exam, where the people must prove that probable cause exists that a crime was committed, and probable cause exists that Mr. Cannon was a part of that crime. He has made a conscious decision to waive his exam. We have executed the form.
All right, people have any objection?
People have no objection.
Thank you. All right, Mr. Cannon, I know your attorney's gone over this already, so it's gonna be a little redundant. I have to go over it too. All right. You understand you have a statutory right to preliminary exam. The state must show by probable cause a crime was committed and probable cause you had something to do with committing it. You understand that?
Yes, sir.
Anybody promise you anything or threaten you in any way to waive your right to preliminary exam?
No, Your Honor.
You waive your right freely and voluntarily after having opportunity to talk to your attorney.
Yes, Your Honor.
Do you sign the waiver of examination form?
Yes, Your Honor.
All right, court will find that you freely and voluntarily waive your right to preliminary exam and is bound over Wayne County Circuit Court Criminal Division for arraignment on the information, which will be October 6th at 9 o'clock.
Thank you, Your Honor.
Thank you, Judge.
You and your staff have a wonderful weekend.
Hey, you too.
Ready on Oni?
Only?
Yeah. Yeah, that's.
Oh, yeah.
All right. Calling case number 230-58135, People versus Chucky Oni. Defendant is charged with count 1, possession by felon, count 2, possession of ammunition, count 3, carrying a concealed weapon, count 4, felonious assault, count 5, assaulting with disinstruction of a police officer, count 6, 7, and 8, possession of deadly firearms. Defendant is a habitual offender, has a forfeiture notice. This matter is for exam.
Philip Henderson on behalf of the people, P86029.
Richmond right, P8209, on behalf of Mr. Owen, who stands to my right.
So only state your name, please.
Sure.
Thank you. All right, ready to proceed?
Your Honor, the people are not ready to proceed in this matter. I just discovered this morning there was a problem with subpoenas being properly served, so we don't have witnesses here to proceed.
Motion for dismissal, we're ready to proceed.
All right. Yes, it's me.
Thank you.
Is that without prejudice? Your Honor?
Of course, yeah, it's without prejudice.
Okay.
Then we'll do it outside. Yes, sir. Okay.
This is parties on Michael. Calling case number 230-58889, People versus Malik Michael. Defendant is charged with count 1, carjacking, count 2, robbery armed, count 3, unlawfully driving away motor vehicle, count 4, receiving and concealing stolen property motor vehicle, count 5, carrying a concealed weapon, count 6, possession by felon, count 7, 8, 9, 10, and 11 is possession of a felony firearm. This matter is up for a probable cause hearing. Appearances, please.
Philip Henderson on behalf of the people, P86029.
Good morning, and this is Honorable Court, Tasneem Sharif, P7 on the platform, on behalf of Malik Michael. I'm sorry, Judge, I missed this one today.
Okay, I missed almost everything you said except for your name. Oh,
I'm sorry, could you repeat that?
I thought I missed everything you said except for your name. You kind of faded out.
I said on behalf of Malik Michaels, I apologize. I missed this today. I'm across the street. I've been running. I apologize for my tardiness.
All right. Okay. We'll send it. Well, your client's not on. You wouldn't waive his appearance for the purpose of this hearing?
That is correct, Your Honor, and I'd like to set the matter for an exam.
Okay, so we'll waive his appearance. Are you available 9:45 on September 29th?
It would have to be in the afternoon. The morning is booked. I can do an afternoon exam or a late morning exam.
Well, what about September 28th at 11:30? Hello?
I'm looking at my calendar, so I'm going off screen for at the 28th.
Oh, okay.
Hunter, and I rarely ask this, but could we do a day different than the 28th? Miss Lewis is assigned this case, and that's one of the only days she's not here in court before you. She's here the 27th, the 29th, the 2nd.
And the 28th actually works for me, but let's go. How is I can do the 2nd, Judge, if that's good for your court.
October 2nd at 10 o'clock.
Yes, Your Honor.
Right.
Thank you, Judge.
We'll get our rights for that.
Okay, all right, see you back October 2nd at 10 o'clock.
Thank you.
All right, thank you.
Sorry, Mr. only has his header on. I was wondering if he ordered to.
Yeah, he takes the order of dismissal along with a registered action. We have to give him a registered action.
Okay.
And then he takes that over there and they'll remove it.
Okay.
You just wait for a second, register action on this, only.
Yes, we'll tell that.
The dismissal should work. You just
Oh,
dismissal.
you need a registered action too.
Oh, that's what they require.
Yeah.
Lately, we've been doing it.
All right, what are we doing with, Jordan?
Ready, Your Honor.
Jordan.
Might as well do that, and then I'll go upstairs and do
All
those.
right. Mr. Brown is right outside the courtroom. Yes, Dwayne Brown is doing this case.
Get them in. It's privilege to step up.
Thank you.
Oh.
Good weekend, enjoy your day, Judge. Take care now. Enjoy your birthday.
That's right.
I will. Don't think it wouldn't
Go Lions.
That's right, we're gonna win Sunday.
Yes.
And if we lose, we all know it.
have. There go Atlanta guy right there. Oh, he's golfing guy right there.
Oh, no, they're not. Atlanta's in your.
Oh, yeah, that's right.
You gotta help the coach out.
Oh, yes, and, I might be playing for the Lions next year too. But I won't come to work though, I won't take days off.
We'll be playing this.
Just don't do any gambling.
That's right.
Yeah.
Oh. Calling case number 230-56963, and that is People versus Shamar Jordan. Defendant is charged with counts. Defendant is charged with count 2, carrying concealed weapons. This matter is up for an exam.
Good morning, Your Honor. Dwayne Brown, appearing on behalf of people. Good morning, Your Honor. David Cripps, P 34972, appearing on behalf of Terrence Michael Jordan Jr.
Good morning, Your Honor. Terrence Michael Jordan Jr.
Thank you.
Now, Your Honor, I have to apologize. I thought we had a couple of minutes. The officer is testifying on stairs. He's the way down. He's there. Oh, he's here? Okay, all right, good.
Can I get your phone number, please?
44578.
Thank you.
Oh, bring him in.
Hovish. Ross. Is that Officer Hovish?
It'll be Officer Maybelline.
Maybelline?
We'll make sure.
J-A-L-A.
May's son.
I'm sorry. J-A-L-A-N, last name?
M-A-B-S-O-N.
Thank you. Judge,
So what's the sentence? Right hand. Sir, you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Yes, sir. All right, you
Yes,
close
sir.
the door towards you.
Is that yes, sir?
Yeah.
See, wait a minute. You did state your name for this record. Officer Madison. And Officer Madison, where were you employed on or about May 16th, 2023? Detroit Police Department, 8 precincts. And in your capacity with the 8 precincts, did you at some point come in contact with someone you later learned to be a Mr. Terrence Jordan? Yes, sir. Mr. Jordan in the courtroom today? Yes, he is. You point him out, indicate where he is and what he has on today? Yes, he has on a green polo shirt with a white long sleeve under with a button. And for this record, the witness has identified the defendant, Mr. Jordan.
Record so reflect.
Could you indicate to the court or tell the court how you encountered Mr. Jordan on that day? Yes, sir. I encountered him through a traffic stop. Okay. What was the location? West 7 Mile Road in Losser. That'd be the city of Detroit? Yes, sir. Do you have an approximate time for that stop? I cannot recall the time right now. Now, so if you would, tell the court the circumstances. Yes, sir. Okay. I was traveling in my scout car, marked scout car, and I observed the vehicle that Mr. Jordan had in at the time. It's going to be a white Chrysler 300 that was traveling westbound on West 7 Mile Road, approaching Losser. The vehicle at this time was equipped with illegal tints on the vehicle, which led to my traffic investigation. Okay, now, you indicated you were in the vehicle. Were you in the vehicle by yourself or with someone else? No, sir. I was in the vehicle with my partners. Okay, who would that be? Officer Jones and Officer Polish. Okay, so you indicated to the court you observed the windows tinted? Yes, sir. Okay, so as a result of that observation, what did you next do? I entered the plate into my lean system to initiate a traffic stop. And did you at some point stop the vehicle? Yes, sir. What happened next? Upon stopping the vehicle, I came to the passenger side of the vehicle and I made contact with where Mr. Jordan was sitting at the time, while my partner made contact with the driver. And what in fact, if anything, happened in your contact with Mr. Jordan? During my contact with Mr. Jordan, he was arrested that day. Okay. Tell the court, what is the first thing you observed when you encountered Mr. Jordan? What happened? The first thing I observed when I encountered Mr. Jordan that drew my attention was a clear cup of alcohol sitting in the center console and smelling an odor of alcohol coming from the vehicle as if someone was drinking in the vehicle at the time. Now, as a result of what you thought might have been alcohol or smell or something like that, what did you do?
At this time, I just stood by and let my partner continue his investigation with the actual driver who we investigated at this time.
Okay, so at what point then did you, at some point then, start doing something with Mr. Jordan?
Yes, sir. So after the driver was then ordered to be removed from the vehicle, I then had Mr. Jordan step out of the vehicle as well. Upon doing so, he also had a clear cup of alcoholic beverage in the passenger door cup holder at that time. I then escorted Mr. Jordan to the front of my scout car to conduct a pat down of his person and issue him a ticket. And at that time, would you like me to continue here?
Now, all right, so you said at some point then you issued a ticket.
Yes,
Okay.
to issue a ticket.
All right,
Yes.
Why was Mr. Jordan asked to leave the vehicle?
Because when the driver is asked to exit the vehicle, all occupants must exit the vehicle. Also, I had reasonable suspicion that Mr. Jordan, as well as the driver and other occupants of the vehicle, were consuming alcohol in the vehicle as passengers and drivers.
Okay, now tell the court, what was that based on?
I'm sorry, can you repeat that?
What was that reasonable suspicion you indicated to the court that you had? What was it based on?
The open alcohol that was actually inside of the vehicle, and also during this time, I overheard my partner get Mr.
Say what your partner said.
I heard
Well,
the driver of the vehicle.
You can't say what the driver said.
well, as a result of the conversation you may have heard, did you do something? You were indicating that you overheard something being said.
Right.
Okay, now, once you heard that, did it cause you to do something?
No, so I had the passenger exit the vehicle due to the driver exiting the vehicle.
Okay,
Yes,
now, was there anyone else in the vehicle?
yes, there was.
Where was that person? Tell the court.
There was another male in the back seat
Okay.
on the passenger side.
Okay. So, you were, why I interrupted you, indicating that you had Mr. Jordan out of the vehicle.
Yes.
Okay. What happens once you got him out of the vehicle, him being Mr. Jordan?
Okay, so during this time, after I had him exit the vehicle and I observed the open intoxicants that was inside of his passenger door, this time he was to be issued his ordinances and to be identified. My process from doing that is to have that individual sit in the rear seat of my scout car, and in doing so, I pat down the person. So I don't allow any contraband such as tobacco, marijuana, lighters in the rear seat of my vehicle.
So is that done in this case?
Yes.
Okay, so what happened?
I conducted a pat down of Mr. Jordan, at which point I patted down his jacket pocket, and I thought I felt a pack of cigarettes or tobacco. During that time, I reached in to pull it out, and what I thought was tobacco products actually turned out to be a stack of Chase credit cards.
So what did you do as a result of that stuff?
I looked at the credit cards to see if they were in Mr. Jordan's name. They were not. They were all listed in different names at that time, which gave me the reasonable suspicion of credit card fraud.
So what happens next at that location?
Now, Mr. Jordan is now under arrest under my suspicion of credit card fraud.
So what do you next do, if anything?
So I then escort Mr. Jordan to the rear of my scout car, and in the process of doing so, Mr. Jordan then tries to flee on foot as I'm escorting him into the back of my scout car. In a failed attempt, I then successfully get him into my vehicle, and then I wait for probably about a couple seconds. There's a firearm recovered from the vehicle at this time, and so I stand by for security purposes, for safety.
Now, you indicate there was a firearm, because where is the firearm recovered from?
From the driver's side of the vehicle.
Okay, so what happens next?
At that time, due to the attempted flee on foot from Mr. Jordan, I got reasonable suspicion at that time that he may have been trying to separate himself from myself due to more contraband that's either on his person or in the vehicle. Yep. Would you like to continue?
All right, so what do you next do, man? You indicated that Mr. Jordan made that move or something. What do you do then?
So then I return to the passenger side of the vehicle. As I'm standing outside the passenger side of the vehicle, I have my flashlight. I shine my flashlight into the floorboard area of the vehicle. Excuse me.
All right, so if you would describe in a little more detail when you said the floorboard, where are we talking? Front,
Yes.
seat, beside the seat?
So I stand from the front of the floorboard to the under where the seat is, from as far as I can see from being outside the vehicle.
And what do you next do?
Next, I observe a handle of a handgun under the passenger seat, the front passenger seat.
Okay, are you able to see that from standing up? Do you have to get in the car or what?
Yes, sir. I was able to see it from standing outside of the vehicle.
And what do you next do, if anything?
Next, I go and I recover the firearm. And from recovering the firearm, I made the weapon safe and I notified my partners of the recovery.
Okay, now, after the discovery of the firearm, did you have any contact with Mr. Jordan as a result of what you discovered?
Yes, I did.
What did you do?
Next, I returned to Mr. Jordan, and inquired if he was in possession of a CPL because he had not been identified at this time.
And what happens at that point?
At this time, I entered Mr. Jordan's name into my lien system to actually verify if he was a CPL holder. Per my lien system, he was not of age to possess a CPL nor a handgun.
What, if anything, did you do at that point?
I informed him of his arrest at this time.
Now, maybe with just on the record, so what type of handgun was it?
I'm sorry, I don't recall what kind of handgun it was. It was a black handgun. I'm not gonna go into the details of what handgun it was. So I'll leave it at that.
But it was actually a handgun?
Yes, it was a handgun, a black handgun.
Not a facsimile?
Not a facsimile. It was loaded with one round in the chamber.
Did you put it on evidence or someone?
Yes, I put it on evidence. Yeah.
Not the first.
Morning, officer.
Morning, sir.
You said that there were 3 people in that car?
In my car or the 300?
The suspect car?
Yes, 3 people.
And 1 person was in the back seat?
Yes, sir.
No further questions.
No further questions.
Thank you.
Judge agreed to do a waiver.
Oh,
So they can go.
okay.
No, just over this final.
Is there any witnesses?
Yes, Your Honor.
A witness?
Yeah.
Yeah.
All right, well. 1 minute, Your Honor. I want to consult with my client. I'm prepared to make argument in opposition to my own.
All right. Go ahead.
Insufficient evidence here in this case. We have 3 people in a car. My client's in the front seat. There's a person in the back seat. There's no showing that my client had any knowledge or possession of the firearm that's found under the passenger seat. Could have very well been placed there by the person in the back seat. We don't know. But what's important to know is when they did a pat down on my client, nothing found in him that would suggest any attachment to a firearm such as a holster or ammunition, anything of that nature. So the fact that he was trying to leave the immediate custody officer is probably due to the credit card. As far as the CCW charge, we believe there's insufficient evidence to ask for dismissal.
Well, John, we would just submit that the behavior of the defendant once the first firearm was discovered, and as the officer indicated, you can say, look, give whatever weight that you want to that, but the officer indicated that the defendant seemed to be a little more aggressive once that firearm, based on the officer's instinct, went to the vehicle. He didn't indicate that he had to do too much.
I'm not concerned about the officer's instinct. His instinct doesn't mean anything. What he did, what he saw, that means everything.
Well, he said it didn't take much effort to observe that gun under the seat that the defendant was sitting.
Okay. All right, so what having heard the testimony and arguments from Officer Jalen's absence, Detroit Police Department, then on 5/16/23 in the area of West 7 Mile Lasher, he did a traffic stop for illegal tents, which is a civil misdemeanor, not a civil infraction, excuse me. That he said he entered the plate into lane. I guess assumed that there was no issue because he didn't say anything else about it. He stopped the vehicle. He went to the passenger side. He made contact with the defendant. The defendant was sitting on the passenger side. There was also a clear cup of alcohol with a stump that was in the passenger door. The driver was taken out. Then Mr. Jordan was taken out. Vehicle. And he was taken out. He was taken to a scout car. He did a pat down. He said he felt what he thought was cigarettes on his person, which I don't understand why he would then reach inside and take the cigarettes out. The cigarettes are not illegal. So, you know, the fact that he wasn't under arrest, he was just being allegedly detained so they could write him a ticket, because that's all they had was a civil infraction at that point. But anyway, he found some a stack of Chase credit cards in his possession and other people's names or in other names. And he intended to arrest him for that. He went back to the vehicle. That's where he observed a handgun from the sticking out one of the passenger side of the vehicle. There's nothing on his record that acknowledges that he didn't have any knowledge of that weapon. There was no movements. There was no. He had no ammunition on him. He didn't have a holster on him. He had nothing. All you got is in the car. And if it's in the car, it goes to the driver. It doesn't go to the passenger, it goes to the driver, unless you can connect the passenger to it. And I don't have anything connecting it to it. That he would know it was there. As a result, the court's going to dismiss.
Thank you, Alex. Thank you, Honor.
Thank you.
Here you go.
Thank you. How you been, Carl? It's been a long time.